Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Our very first podcast was on the single justice procedure, that important but little-known part of the criminal justice system. Today, just over 2 years on, we're returning to what is known as the SJP. We're going to do a slightly different format because I've just written and published a report on the SJP for Transform Justice. So today, Rob is going to be sole host, and I'm in the hot seat, together with Kirsty Brimelow KC, eminent criminal barrister. Before I swap seats, I just wanted to ask you something, Rob. So, from what I can see, there's been really little research on this subject up until now. Why do you think that might be?
Well, you're right. Given the number of people that go through this system, it is very surprising that there hasn't been much research. I suppose it's at the, if you like, the shallow end of the system. It's the least serious cases. People aren't going to prison as a result of what goes on here. A more cynical bit of me thinks perhaps the government doesn't really want detailed scrutiny of this because so many people go through it. It's almost too big to fail.
Good point.
It's a little known process. Can you take us through exactly what it is we're talking about here?
We're talking about low-level crimes like not having the right train ticket. And what happens is somebody's caught, and if they're prosecuted, they get a notice through the post, and then they're supposed to fill in the form, the prosecution notice, either in longhand or online, saying whether they are pleading guilty or not guilty to the offence. If they say they're not guilty, they will get a proper trial in the magistrate's court. But most people either say they're guilty or don't say anything at all. Then that case is not in an open court like you think of in a magistrate's court. It's done in a closed court by a single magistrate sitting alone with a spreadsheet in front of him, going through convicting and sentencing up to 100 people a day.
Right. We'll get into the weeds of it a bit in a minute. Kirsty, can I ask you, when did you first become aware of the single justice procedure? Because I think it sort of started without any great fanfare and then became more and more important, didn't it?
Yeah, it's definitely picked up volume and speed. I became aware of it during COVID with the COVID regulations. And we discovered that people were being convicted through the single justice procedure of offences which, in fact, either the SJP had no jurisdiction to try them under, or they quite simply weren't guilty of an offence because a guideline was being applied rather than the actual regulations. Well, I've looked at it more over the years and I've been increasingly concerned about the lack of transparency. And one of the big issues, in fact, is there usually will be some filter by a lawyer in processes of prosecutions. What happens now with the single justice procedure is there's no lawyer to filter at the beginning. It goes straight to the magistrate, who's a lay magistrate. That means they're not a lawyer. And it's only if they spot that there might be something wrong or there might be some legal issue that then it is alerted with the court clerk. But you can see immediately the problem. They'd need to really have some legal training to spot that there might be a legal issue.
So there isn't a lawyer there the whole time when they're dealing with this?
Only if they spot a problem. And you really need the legal training to spot the problem in the first place.
You don't know what you don't know. So, Penelope, it sounds like quite a lot of drawbacks to the system, but it now accounts for half of all of the criminal prosecutions in this country. How did that come about?
It's incredible, isn't it? I mean, this is where the unknowns come in, because this report was pretty frustrating in terms of finding stuff out. But what you can see is this amazing line going up of SJP cases. Actually, these prosecutions by railway companies, by the police for speeding offences, by the DVLA for not having your licence and MOT, happened before the SJP was introduced 10 years ago. But what we don't know is the volume of cases compared to the open court cases before the SJP was started. What we can see is that more and more of those type of prosecutors, you could call them private prosecutors, have been allowed to use the SJP over these years. What might also have happened, but we don't know, is that they've got the bug of prosecuting this way because it's quite easy. And so that they've actually ramped up the average number of prosecutions they do.
And so a lot of them are kind of fare evasion. You've mentioned some of the kinds of offences, people travelling on buses and trains without a ticket.
It's not just necessarily without a ticket. What we're talking about here is people found either without a ticket or with the wrong ticket, people who can't show that they've got a TV licence, those kind of things, and a lot of police motoring stuff.
Kirsty, a lot of the offences which go through this system are what's called strict liability offences. Can you explain what that means and whether that has implications for people who are trying to defend themselves against allegations?
Yeah, so strict liability is where there isn't a defence of, for example, I didn't intend that to happen, I forgot some crisis happened to me. That would all go to mitigation. So strict liability is really black letter. Did you do it or not? Guilty, not guilty.
By mitigation, you mean that should be taken into account in deciding how to sentence
On
the
the
person?
sentence, yeah.
So if somebody makes a genuine mistake, it doesn't matter, they're guilty, but that could be taken into account so they get a more lenient sentence.
Yeah, but of course, what should happen and what happens in the usual prosecutions in the magistrates' courts before they actually get to court is the Crown Prosecution Service. They have to apply it. So it's called a two-code test. So first of all, you look at, is there sufficient evidence? And then secondly, and importantly, is it in the public interest to prosecute? So what can be seen as mitigation, where somebody's in a mental health crisis, people having cancer treatment, chemotherapy even. And because of that, there has been some infringement of perhaps taxing a car or
because they've
renewing
simply forgotten about it.
Well, because they're overwhelmed undoubtedly by having chemotherapy. Now, normally you would expect that a fair and just system would look at something like that and say, well, it's not actually in the public interest to prosecute them. But we don't have this with the single justice procedure. There's no public interest test that's applied, and there should be.
Did you come across some of these sort of cases?
Yeah, this was perhaps the most sort of shocking revelation to me, that it facilitates the prosecution of people for literally making a mistake. And there was a good example in a report by the Office of Rail and Road. And it had a young woman who's found on a train, and she'd bought a ticket and she had a young person's rail card, but she'd ticked the box of having a student rail card. So she'd actually got the wrong ticket because she hadn't got the rail card for the ticket that she had. But small mistake, and not one that actually made a difference to the price of a ticket.
The discount was the same for both.
The discount was exactly the same, and she was threatened with prosecution, which just seems both balmy and unfair to me. And there's another one which I also find unfair, but for a completely different type of reason, because it's not so much a mistake as a kind of very human situation, which is that it's a crime for parents not to ensure that their children go regularly to school. And, you know, it's framed as a crime because obviously schools don't want parents to whip children out for holidays and stuff like that. But what it is a strict liability offence. So a parent can be convicted because their children doesn't go regularly to school, not because they took them on a Mediterranean break, but because their teenager is incredibly challenging. Say it's a 16-year-old boy and this is a mother, you know, it is pretty difficult to get that child to school, and they can still be legally prosecuted whatever the reason. There are a set number of reasons you can use, but your teenager being really, really difficult is not one of them.
And I expect mothers are probably overrepresented among that group rather than fathers, much as we heard when we discussed this before about the TV licence issue. It's more women that tend to go through the system.
Absolutely. Though I would say again, data whole, who are the people who are prosecuted under the SJP? We have a minimum amount of information.
I mean, Kirsty, you mentioned during the pandemic, you took on a few cases of people prosecuted for breaches of the regulations. Did people understand the legal situation they were in there? Did the single justice procedure help at all in that?
Well, one of the issues was that the politicians didn't understand what the difference was between the regulations and the guidance. So undoubtedly, members of the public, they don't really have much of a chance. And it's very, very difficult because they're brought into the single justice procedure. They're filling out a form, as Penelope has said. They have no access to legal advice.
Yeah, because you don't get any free legal advice for this level of offence.
And in fact, if you were to go and get legal advice, you would be paying out more than the fine is likely to be. And people, therefore, as Penelope also said, would tend to put guilty, and then in the mitigation, they would set out something which probably was a complete defence to it. And those cases that myself and a couple of my colleagues managed to get hold of, we were able to do something about those cases, but they're absolute tip of the iceberg. And what always troubled me was that undoubtedly people caught up in the system were those who were the most vulnerable, they were the most cash-strapped, they were going through different types of crises at the time. And yet they were the ones where it was felt that the private prosecutions somehow were appropriate, and they weren't appropriate. It was just that nobody was looking at it. So it was a revenue-generating exercise rather than something I thought was benefiting society.
I mean, Penelope, in your report, you say that quite a lot of people, in fact, neither plead guilty nor plead not guilty. And this was particularly the case during the pandemic. So what's going on there?
Again, we should all know, and we don't, what's going on there. So around 2/3 to 3/4, depending on the crime, of people do not respond at all to this form. So something is going wrong. They might not receive it because it's just sent ordinary post.
Not recorded delivery or
nothing recorded. And, we're talking about, it could have been 5 months previous, whatever happened to the person. And they could have moved house. They might live in a house of multiple occupation where lots of post gets lost. But also the big thing is, can they understand the form? Can they easily get help to fill in the form? Do they have mental health problems, etc., etc.? This fantastic journalist, Tristan Kirk, does tweets where he gets hold of the case papers and he talks about people who are having cancer treatment or whatever, who say, I'm really sorry that I missed the date to get a license for my car. But what about the rest? If Tristan can find in filled out forms lots and lots of people who are in a situation of almost crisis, then what about the ones who are not responding? Presumably there's thousands there who have disabilities of some kind. They might have mental health issues. We also don't know whether they speak English as their first language.
I mean, and those factors might be the very ones that mean that they don't respond if they're...
Exactly. And I think a lot of people panic with official posts, don't they? And the kind of narrative over time from the government has been, oh, well, we give them the opportunity to respond, and if they don't, they don't. But that, to me, it just isn't right. If 3/4 of the people are not participating in a process which involves their own conviction of a crime, then the system must be going wrong somewhere. Do you agree, Kirsty?
Yeah, I do. You talked about multiple occupancy of residences, but also there's obviously people who are homeless. And it's impossible, really, for them to deal with post coming to a place of residence. So it just captures a lot of people in a system where the finances ought to be into social support of those people rather than these private prosecutions, particularly, as Penelope has said as well, because they're so opaque. We've got one journalist who has taken it upon himself, does a fantastic job of publicising and tweeting those cases, and nobody can read them and think, actually, this is a just prosecution. And that's what concerns me, if people start to lose faith in the system.
Can I just add to that? I think the central problem is you've got prosecutors who don't feel that it's their responsibility to find out about the circumstances of the people they're prosecuting. So hence you get a lot of people in great difficulties being prosecuted. But it's clear that the prosecutors actually don't know that either. You know, the first they know that the person has been in terrible crisis is when Tristan tweets it, which is a crazy situation, because if it was the Crown Prosecution Service, they're not perfect, the system's not perfect, but if people are arrested and taken to a police station, there is an effort made to assess whether that person has got a disability of any kind. And then that information should travel through the system to the CPS, who can take it into account. And the imbalance here is that the CPS, the seriousness of the crime is part of their judgment as to whether it's appropriate to prosecute when somebody is deeply vulnerable. And here we're talking about really low-level offences where, to be honest, I don't know what you think, Kirsty, but I don't think most CPS prosecutors would go ahead with these kind of cases.
It's difficult to say, isn't it? But you'd certainly have a challenge if they're applying the public interest test. Also, the system doesn't allow for any flexibility around posts being lost, around somebody in an unstable situation who hasn't got the notification. And most processes allow a time period for somebody to respond. So why can't there be a similar time here? If a private prosecutor has made a decision that they want to prosecute you, you should be allowed a 3-month period to challenge the lawfulness of that prosecution, because you should be able to say, look, this isn't actually in the public interest. And you'll be able to do that with the Crown Prosecution Service. But we can't do it on all these various private bodies.
So these private prosecutors don't have to take into account the public interest.
They don't, and they should do. So that's one reform that really is necessary.
But just to play devil's advocate slightly, we've talked about Tristan Kirk, the journalist who highlights some of these cases. Presumably he's seeing papers that do allude to the fact that somebody has got a vulnerability, a disability, a really serious crisis going on in their lives. So there is the ability for defendants to write that on the form. Is that right?
They can, but I think that the problem is that it's too late by then. It's already being prosecuted. It goes through a system where it's going straight to the magistrate who's got a decision. We've got a guilty plea here. What do I do?
Yeah. And I think the form is a challenge, actually. And, you know, there are several challenges with it. One is that what it doesn't set out very clearly is this issue about what defences could you use. Now, obviously, it's not in the interest of the prosecutors to do that, but it's only justice. You know, if you get legal advice from a lawyer, they will go through what the defences could be and listen to your story. But these forms, nothing associated with them says, this is a strict liability offence, these are the only defences you can make. And if you have a good defence, you shouldn't plead guilty. What I worry about is when you read Tristan's tweets, as well as people probably committing the offence but having crises in their lives, there are people who don't seem to have really committed it at all, who really shouldn't have pleaded guilty. But there is no explanation. And the mitigation boxes that I've seen, again, we're talking about people who know nothing about the law, give no indication whatsoever of what to put in the mitigation box. It just says, write down anything you think basically the court should know about what you did, which is so broad and vague that I think
it also used to be optional as well. I don't know if that's still there, but
it was
in brackets optional. So if you're filling that in, you think, well, actually, it's not particularly important, this bit. I won't write anything.
And any evidence as to whether the magistrate making the decision actually does read it and take it into account when forming a view about the sanction?
To be honest, I think this is where Tristan's really had success, because I think there was a period where they really just didn't take much account of the mitigation box, apart from in modulating the fine possibly a bit. But actually, I've been looking at the register of all the outcomes recently, and I think I'm seeing an indication of more cases where the magistrate has, as it were, stopped the case to refer it so that it gets dealt with in open court. So I think it's improving a bit.
See, my problem is that by the time you get to the position where the magistrate might refer it to be dealt with in open court, you can say in some ways that's great because they've recognised here that there shouldn't be a guilty plea, but it still doesn't deal with why is it in the court in the first place. And looking at the advantages of SJP, it is to take away that aspect of somebody having to go to court. Because I remember when I started in practice, there would be a whole court dedicated to these kinds of prosecutions and the person would have to be there and et cetera, et cetera. Whereas this in some ways can be effective and it can streamline a process. But the problem is it's actually gone too far. So it's become a sort of massive trawler net that has captured absolutely everyone within it. Whereas if you had a system just at the beginning and stop them coming, that's a public interest, then that would save the problem of somebody who shouldn't be there in the first place and ending up having to defend it in open court.
I totally agree. But I mean, in my ideal world, the prosecutor would seek this information about the circumstances of the person and a bit more context about the crime. And then the person would get the opportunity to challenge the prosecution. They get a bit of help to know how they might be able to do that. And I agree with you. Then you would stop the cases actually getting to court, which shouldn't get there. This is where I think that Rob's point about too big to fail might come in, because that takes what is now a very speedy, cheap process and makes it much nearer what the traditional court process is, which is slower, more expensive. So I kind of think there might be quite a lot of system resistance to our ideal scenario.
What I'd like to see, the magistrate should get those cases and send them back to the prosecutor. Say, are you really going to prosecute these? Have another look.
And they've got that power to do that.
They would have the power, but currently it's not something that they recognise as being a power. They're in a process where procedurally they take a decision on what the sentence is when they come before them because they've got somebody who's pleaded guilty. So you'd have to set up a system which makes it clear that they can send it back. And the magistrate saying, actually, I'm not satisfied with this prosecution. The only way they probably do that as well would be to have a more proactive clerk, a lawyer to also help and advise, because it is a lot of responsibility on a lay magistrate when these companies are massive.
Yeah. I mean, we've mentioned Tristan Kirk a few times, and in fact, we had him on, didn't we, Penelope, in our very first podcast all those years ago. I mean, is he, and to an extent you, Penelope, the sole scrutineers of this system, or is there anybody else exercising some oversight?
Not enough, I would say, not enough. I have been lobbying for years to try and get a parliamentary committee to do an inquiry about it. And they sort of touched on it when they did an inquiry about COVID-19 offences and how they were dealt with. But it didn't look at the system as a whole. So actually, it's had precious little scrutiny until now there's a little bit more. And I think it's partly because, dare I say, lawyers aren't involved most of the time. Kirsty's rare in knowing about it, but a lot of lawyers really don't know about it at all. And that can help with scrutiny if you get lawyers involved.
Kirsty, I wanted to ask you about one aspect of this, because a number of railway companies misused the law relating to this for several years.
Yes.
Nearly 60,000 cases of wrongful convictions. I mean, was that just a sort of slip-up that happens in any large-scale system, or do you think it says something about the system itself, lack of oversight, lack of it being taken seriously? It seems quite serious to me.
Yeah, so that was a case which was actually challenged by a passenger who was using the particular railway network. There was an issue of him getting a ticket from a ticket machine, the ticket machine was broken. He didn't get that ticket at that time, but he had another one that was basically no loss, but he ended up being prosecuted under the SJP. He challenged it, and from my understanding, he managed to get himself in a little forum where there were some lawyers there, where they also pointed out that the particular offence for which he was prosecuted was one which could not go through the SJP. So it was one where the single justice procedure had no jurisdiction. It had to go through the normal magistrates court. And that was conceded by the railway company. And then, of course, they had to concede the 59,000 other cases that they had prosecuted through the SGP when there was no jurisdiction to prosecute through that process.
You know, the law is complicated and there are different offences for basically fare evasion. And he was prosecuted under not having the right ticket, which you can do under the SJP, but for deliberate fare evasion, basically, which you can't do under the SJP.
Just to press you on, I mean, what do you make of that? Is that a sort of, you know, these things happen, mistakes are made? Or is there something more serious than that?
I think it is really serious. And the reason is that you have people convicted under a process where there was no power to do that. And secondly, there probably will be people within those who were convicted who did not pay their fine. So that would mean that there'll be a further prosecution. And that leads to a criminal record. The knock-on effect of having a criminal record can be huge. It could impact on your employment. It could impact on all sorts of aspects of your day-to-day living. And when you look at that and see that all of that was unlawful, that is very serious. And to get to tens and tens of thousands with nobody actually noticing is pretty shocking.
Yeah, I was shocked by that because I sort of assumed that the first question a magistrate would ask is, well, you know, have I got jurisdiction to deal with this kind of case in this kind of way?
You would have thought, here's a list of the offences that come under the SJP, and be very alert to if there's another offence coming in under SJP which isn't in your list. So I don't know what happened there.
I mean, to me, it's more the responsibility of the prosecutors and the legal advisor, because a lay magistrate isn't supposed to be legally
I agree. It's
trained.
putting a lot on their shoulders.
Yeah, and the
they're
legal
not
advisor,
legally trained.
that's the point of having a legal advisor involved in the process, but also for the prosecutors for 4 or 5 years, as it was, to keep prosecuting under this system when it was not legally allowed seems pretty amazing.
Yeah. Penelope, I think there are one or two rays of lights in this sort of field, aren't there? Can you tell us whether you're optimistic that we might see some change?
I mean, to be honest, we keep saying Tristan Kirk, but it is true that partly because of him, the awareness of these problems is increased a lot. And the new government actually from quite early on has said, oh, we've got concerns about this, and they have consulted people about private prosecution in general. So partly driven by the Post Office, which was a private prosecutor, but also they're looking at the SJP and proposing different practices for those who prosecute under the SJP. So to me, that is, well, it's positive if they action it, but it is positive anyway. What do you think, Kirsty?
I think the fact that there's been a consultation on private prosecutions and also looking at safeguards to justice in the single justice procedure is a really big step. But also what I found quite positive is the framing of the questions in the consultation, which was looking at public interest. It was clearly looking at suggestions to make the SJP more transparent and actually safer for people who were caught up within it. All of that is good. And I remember from like 2020 onwards, giving evidence before the Justice Select Committee and other parliamentary committees. And nobody would really know what the SJP was. And then that understanding kind of developed. And I also remember getting lots of pushback from magistrates saying our system works perfectly well. But then, I think it was last year, the Magistrates Association came out with a public statement that there wasn't sufficient transparency, and they are advocating reform, which is great because it's not in their interests either that they have magistrates put in this terrible position where they're not lawyers, they're not being supported by a lawyer, they're having prosecutions which are being brought, and the buck is always going to stop with the last person who's touched it, which ultimately is going to be the person who's handing out the punishment. There's a big issue as well which needs reform, in that people are getting much heavier costs than they would get in a magistrate's court. You have people with limited means. They don't seem to be means testing in the way that would happen in a magistrate's court. So people seem to be being punished as well.
So this is a contribution that somebody who's guilty has to pay towards...
Yeah, so it's a prosecution cost, but there's no transparency on where those costs actually come from.
Well, it should be a lot less, shouldn't it, if it's a cheaper system?
It's a very cheap system. I mean, it seems to be push-a-button type of system.
Well, perhaps the National Audit Office should look at it as well.
I just want to agree with Kirsty about the total costs here. We're talking about somebody who is caught because they don't have the right bus ticket. You know, we might be talking about value £2. And if they're convicted, they can end up with the average costs and fines amounting to over £500. To me, it just seems disproportionate, as Kirsty said, compared to some of the costs and fines which are meted out in the magistrate's court.
And probably unlikely to be paid in many cases.
Well, who knows? But that's not the point, really, is it? Because if some people who are very poor are facing these disproportionate costs, even if they don't pay, it might be causing them huge trauma and stress in their lives, and presumably is on a record somewhere.
The concern again really comes back to, if you set people up to fail through a sentence, then you are setting up for greater conflicts with the justice system for that person. And if your core infringement has come from a crisis, from extreme ill health, from bereavement, from whatever else is going on in people's lives, then I think standing back, those probably aren't the people we should be wanting to criminalise in our society.
Well, there's clearly a lot wrong with this system, it seems to me. We need to, I think, bring things to a close. The way we end these, as you know, is to ask each of you, if you were Lord Chancellor, what one change would you make, in this case, to make the SJP fairer? Kirsty, can I ask you?
I absolutely would bring in a public interest test at the point of prosecution that the private prosecutors have to apply, and be ready to give reasons to a magistrate if they are bringing a prosecution.
Thank you. Penelope?
I would go to the participation rate, and I'm not sure what the answer is, but I would say that there should be a commitment to vastly increase the number of people who actually plead guilty or not guilty. Because to me, that lack of participation indicates that this particular justice system is broken. What about you, Rob?
Well, we started this discussion by agreeing that there hadn't been a lot of research on this. And one thing that occurs to me is whether we need to reintroduce a kind of courts inspectorate to get to the bottom of what's going on. There used to be one. It was scrapped, I think, in 2010 in the austerity. But given the social costs and costs of justice we've heard about here, I think there's a good case for reinstating it.
I agree with all of those, actually. Thanks, Rob and Kirsty. And our new report is available on the Transform Justice website, and we'll put other relevant links in the programme notes. Thanks and goodbye.
Goodbye.
Thank you. Bye.